Hi, I'm Katherine Franke. I'm a professor at Columbia Law School, and I'm the faculty director of the Law, Rights, and Religion Project. I'm joined right now by Elizabeth Reiner Platt, who is the director of the Law, Rights, and Religion Project. And we're excited that today we're issuing a new report called We the People of Faith, the Supremacy of Religious Rights in the Shadow of a Pandemic. Liz, what does the report mean by the supremacy of religious rights?
Sure. So what we've seen over the course of the COVID-19 pandemic is that the Supreme Court has now created a new constitutional test for the protection of free exercise of religion that is more robust than its standard for basically any other fundamental constitutional right. So during the pandemic, we saw countless different lawsuits involving all sorts of different constitutional rights. So in cases involving the right to access abortion during the lockdown, the rights of people stuck in crowded prisons, the right to vote, free speech. But most of all, what we saw is tons of cases being brought by houses of worship and by individuals who were challenging the constitutionality of COVID public health measures that limited their ability to gather in large groups for worship, just as they were limiting all large gatherings. And what we saw is that the Supreme Court ended up treating all these various cases very differently, really starting with the appointment of Justice Amy Coney Barrett to the bench. The court hugely expanded protections for religious practice and limited states' ability to enforce these public health measures on religious institutions, while at the same time granting far weaker levels of protection to the other COVID-era claims involving other rights.
Now, in the report, you describe this new standard as discrimination on steroids. What do you mean by that?
So what the court says is that anytime anytime a law or a policy has any sort of accommodation or exception for any reason, it has to grant the same exception or accommodation to religion, or it's discriminatory. So anytime religion is not given the most favorable possible treatment under the law, that's discrimination. That's not the definition of discrimination that we use for anything else, not for discrimination based on race or sex or anything else in the Constitution.
That's interesting. So you've described how the advocates for broader religious liberty protections under the idea of religious discrimination kind of exploited or saw as an opportunity the COVID pandemic. Is this new approach to religious liberty that we've seen the court embrace something that will outlast the pandemic, or is it really only related to the pandemic itself?
It will certainly outlast the pandemic. So the new kind of discrimination standard, discrimination on steroids, as you said, that we describe, is not limited to the pandemic. It applies throughout federal, state, and local law and policy. And if you think about it, there are countless, almost every single law and policy on the books has some sort of exception or limitation. So whether it's our civil rights laws that often exempt small businesses or small employers, whether it's our minimum wage laws that often have exceptions for tipped workers or contract workers, whether it's even something as basic as traffic laws that may accept emergency vehicles. If the standard is that it's unconstitutional discrimination for a law to have those kinds of exceptions but not accept religious objectors, we're going to see a much, much broader right to religious exceptions from the law that again outlasts the COVID pandemic.
That's interesting. So it really could apply to any law.
That's right.
That's wild. So last week, the Supreme Court issued a decision in Fulton versus Philadelphia. It was a case where Catholic Social Services sought a religious exemption from the city's human rights law that prohibited discrimination on the basis of sexual orientation. And the court granted Catholic Social Services request for that exemption. The opinion, remarkably, was unanimous. There were no dissenters. Did that opinion differ in any way from the COVID cases, or did you see it really solidifying the direction that the court's approach to religious liberty had been taking?
It really wasn't, I would say it was in the theme of Tandon v. Newsom and the court's COVID cases. What the court said was essentially because the city of Philadelphia allowed for exceptions from its anti-discrimination provision, even though notably no exception had ever been granted, it merely allowed for the application of exceptions, that therefore Catholic social services must be granted an exemption from the anti-discrimination provision. So again, that's quite similar to the COVID standard. But I would still say that it is quite a troubling development, because it shows that the Supreme Court is open to allowing exceptions from interests of the very highest order, whether that's public health or civil rights. And it also shows that the court is open to allowing the incorporation of religious standards and values even within a government and government-funded program. So Katherine, you're a co-author on the report, and a major theme in the report is on the new sort of tiering of constitutional rights. And I wanted to ask you if you could speak to that point a little bit further.
Sure. Before this new line of cases around religious liberty, the way that the Supreme Court kind of held all of the rights that are secured in the Constitution was in a kind of healthy relationship to one another, a kind of ecology of rights, and they were balanced against one another in a really thoughtful way. And what we're seeing now is that there are certain top tier rights, religious liberty, and protections against religion-based discrimination, and then second tier rights, like the rights of LGBT people, like the rights to race discrimination and sex discrimination. And this is a brand new idea, that certain constitutional rights are supreme over other constitutional rights. And it's part of why we're so concerned about this trend, because it puts the court in a very different position of privileging some kinds of rights and some kinds of citizens over the rights of others. How do we access the report titled "We the People of Faith, the Supremacy of Religious Rights in the Shadow of a Pandemic"? Where is it, Liz?
It's on our website, lawrightsreligion.law.columbia.edu. And we'd also encourage you to tweet about the report at #WeThePeopleOfFaith.
Great. Thanks so much, Liz. And I hope you all download the report and take a look at it.
Thanks so much.